May I invite all the speakers onto the dais? Dr. Kaza,
I hope everybody is settled down. There is still 4 minutes left to say good afternoon and therefore very good morning to all of you. Uh, Here today we are going to discuss Bharatiya Sakshya Adhiniyam. Since we are discussing about the new legislation which is going to implement it from 1st July, we are going to say goodbye to the formerly known as Indian Evidence Act. And whenever we say goodbye to someone, we become a bit nostalgic. And today I have all that feeling of nostalgia because where I learned law in Pune, we had a very good professor known as Mr. Irani. And till today I distinctly remembered in his unequivocal eloquence, in his introductory session, he used to say that the best legislation is ever drafted by anyone, that's James Stephen, and that's Indian Evidence Act, which had at least minimum very few amendments, and that too amendment because of technological changes. So with this nostalgia, today we are going to discuss and deliberate in this session Bharatiya Sakshya Adhiniyam. Today's session will be chaired by Senior Advocate Jaideep Gupta sir. He has handled various commercial and constitutional litigations for more than 30 years before the Supreme Court of India and the High Court across the country. He is a family member of the Bar Association of India. He has started practicing before the High Court of Karnataka in the year 1985 after pursuing his education from the University of Cambridge, and he started his career in the chambers of former Attorney General Shri K.K. Venugopal. I request to the Honorable Chair, please start with the session. Over to you, sir.
thank you, Mr. Pravartak Pathak. We are going to delay your lunch a little bit, not too much, because we are starting a little late. I have asked my speakers to speak for about 15 minutes instead of 20. We will have discussions, if any, at the end if there is some time, and if you're still not hungry enough to rush for lunch. This session is on the Evidence Act. I have a feeling that most of us will continue to call it an Evidence Act for a while. It's called the Bharatiya Sakshya Adhiniyam, which even in my poor Hindi does not add up to evidence. Of course, as we explore the nitty-gritty of these legislations, it is important to grapple with individual provisions. But I'd just like to point out that this entire session and the entire conference is a once in 2 year conference which our President of the Bar Association of India, Mr. Prashant Kumar, started 2 years back. And the idea is to debate on issues relating to the rule of law, which as we understand is absolutely central to the concept of a democracy in the modern world. So I would invite our speakers also to dwell a bit on whether they feel that the rule of law has been strengthened or weakened by the new legislation. I'm very happy Mr. Pathak mentioned Mr. Stephen, who was responsible for codifying the English law of evidence. I studied under a gentleman who was in the process of trying to codify the English criminal law without, of course, any success so far. His code is ready, but nobody is prepared to enact it. And he used to tell us about Stephen, who codified the law and then found no takers in his home country to legislate it, for which I believe in the latter part of his life he was very troubled. However, the colonies, I know that's a dirty word today, but however, in the colonies, his codification was given effect to in the Indian Evidence Act and followed as the Indian Evidence Act in many parts of the colonial empire. Now, there are many aspects of colonization which is entirely abhorrent in our modern day sensibilities. Many. But not every aspect of colonization is like that. The Indian Evidence Act has stood the test of time, and with the minimum of amendments over the years, it has been able to handle technological changes which has taken place from the time it was enacted till today, including the possibility of using electronic evidence. Of course, some additional amendments were required to fully deal with that aspect. With that, I would invite my speakers to take over the session. As a chairman, I'd like to keep my comments down to the minimum possible. My first speaker today is Mr. Aditya Sondhi, Senior Advocate in the Supreme Court of India. He has served as Additional Advocate General for Karnataka in 2016 and 2018. And he is a graduate of the National Law School of India University, which, as you know, is a revolution in legal education in this country, the benefits of which are in the last few years become apparent. We have now a large band of very, very proficient and successful practitioners and judges who have been thrown up by the new system of education. Mr. Sondhi, all yours. I'm sorry, I didn't realize he was a PhD from Mysore University, and I should be referring to him as Dr. Aditya Sondhi.
Thank you, Mr. Gupta, for that kind introduction. Mr. Acharya, my esteemed colleagues, ladies and gentlemen. My thanks to the Bar Association of India for this invitation to speak to you on the BSA. I'm also grappling with the Sanskrit Hindi. Maybe in due course I will get the phrases right. I had the privilege of making a presentation before the Parliamentary Committee leading up to these three laws. And there, of course, I didn't focus so much on the Evidence Act as much as the other two enactments. And I think when we're looking at the evidence law, as Mr. Gupta mentioned, we need to look at it in the overarching umbrella of the three laws together and their effect on the concept of rule of law. A citizen-friendly law may lead us to ask a question as to which side of the fence the citizens stand. Are citizens bloodthirsty for justice, or are citizens keen on a human rights-based criminal jurisprudence which takes into account the rights and protections available to the accused? And I share the view of the earlier speakers that this entire exercise of formulating this new criminal architecture really could have been avoided in the first place by way of appropriate amendment. And if it had to be undertaken, I think there were many, many other facets of criminal law that required to be addressed which have not been done. I won't go into the substantive law except to say on the substantive statute, on the BNS itself, read with the procedural code, considering how far Indian jurisprudence has gone on the death penalty sentencing and conviction matters, this was a golden opportunity for us to legislate a completely new regime on death sentencing. If not abolitionist, at least reformist. We missed that bus. In fact, we have introduced more sections with death penalties. But that said, I come to the BSA. Now, the first point I want to make is that this is an evidence act that applies both to civil and criminal proceedings. We must keep that in mind. So, in trying to focus on a revamp of criminal law, collaterally, we have now also introduced a new evidence act for civil proceedings. I wonder how much thought has gone into the effect of this law upon civil proceedings to be initiated after the commencement of this act, that is July 1st. Interestingly, the preamble to this act says an act to consolidate and provide for general rules and principles of evidence for fair trial. Now, fair trial, in my understanding, generally is a phrase that is used qua criminal procedure. That's not to say it is inapplicable to civil proceedings. But I think with the focus on a reform on criminal law, willy-nilly, we've now brought in a new evidence law which will apply to civil proceedings, and I'm not sure how much we have thought about those implications. Having said that, I am firmly of the view that if these three laws had to be introduced, the Evidence Act should have been a special criminal evidence act. This is not alien to jurisprudence. There are many jurisdictions in the world where you have special police and criminal acts that deal with evidence only for prosecution and criminal matters. The UK has it, Canada has it. This was a great opportunity for us. And there are many elements to criminal trials which are peculiar. Hostile witnesses, stock witnesses, tutoring also. They may overlap to an extent with civil trials, but their effect, again from the rule of law perspective, is more pernicious, more particular in criminal trials. We could have, in fact, looked at a special criminal evidence act, which unfortunately we did not. As was said earlier, by and large, it is a repackaging. Most of the provisions under the old act find themselves couched in the new act, maybe in different clauses, etc. In essence, one and the same. The interesting part is the provisions dealing with electronic evidence. Now, this entire regime of electronic evidence under the Evidence Act itself was a superimposition, because when the act was brought into force, obviously Mr. Stephen and others were not thinking about mobile evidence or electronic evidence for that matter. And we know from experience the difficulty in dealing with electronic evidence as to its admissibility, mode of proof, and how it impacts the outcome of trials. And I don't have time to go into it except to say series of judgments, Sandhu, Anwar, and Arjun Pandit Rao, have taken diametrically different positions. And I have myself been involved in cases, 302 cases, where the investigating officer, those were the early days of 65B, unaware of the requirements and rigor of certification, simply chose not to have those certificates filed in court. And these were circumstantial evidence cases. I was for the victim. These were cases where there was no direct evidence, and the offense could not be proved simply for want of 65B. And questions arose there. Was the requirement of electronic evidence a matter of admissibility, or was it a mode of proof? And this is very important, because if it is an admissibility issue, then whether the accused objects to it or not, there is a threshold bar. The court can't look into it. But on the other hand, from the interest of justice perspective, in cases such as the one that I was appearing, where the accused has not raised an objection to the call records being marked and exhibited, could you still say that there is some bar to relying upon that evidence, or could it be said to have been waived? I think this issue was at large. Sandhu said something, then Anwar said something else. Ultimately, in Arjun Pandit Rao, the Supreme Court said, no, it's mandatory, it's an admissibility issue. However, it can be produced at any stage. Now, this required series of judgments of the Supreme Court. The impact of this ambiguity on trials at every stage was different. It's a different matter who gets the advantage. In some cases, the accused may get the advantage, in some case, the prosecution may. But in either case, it does not sit well with the idea of rule of law that you have ambiguity on something as important as this. And today, in any criminal trial that you look at, you are by and large going to rely on call records, on CCTV, on video evidence, on emails, on WhatsApp chats, on Telegram chats, and so on. And this could have been, I think, the heart of this special Criminal Evidence Act that we could have enacted. We've not done it. What we've done instead now is a contradiction in terms. You have clause 57 of the BSA, which speaks of primary evidence, and in explanation 4 and 5 to 57, the law reads that where an electronic or digital record is created or stored and such storage occurs simultaneously or sequentially in multiple files, each such file is primary evidence. And 5 also says, where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence unless it is disputed. So the onus shifts. It then requires the accused to dispute that evidence, failing which it is primary evidence and therefore admissible. That is the first blush reading of 57 with 61. And 61 of the new BNS says, nothing in this Adhiniyam shall apply to deny the admissibility of an electronic or digital record in evidence on the ground that it is an electronic or digital record, and such record shall, subject to 63, have the same legal effect, validity and enforceability as other documents. So on the one breath, we have elevated electronic evidence now to primary evidence, but subject to 63. Now when you come to 63, it's a non obstante clause. And it says, notwithstanding anything contained in this Adhiniyam, etc., such electronic record shall be deemed to be also a document if the conditions mentioned in this section are satisfied. And those conditions take us back more or less to what 65B required. And we are now left with the same conundrum. Is it an admissibility issue or is it a mode of proof issue? On the one breath, you say only if disputed. Let us say the accused does not have proper advice or a good defense counsel, does not dispute the electronic record. Then what happens? Is there a bar on admissibility? Can the Sessions Court still look into it minus the certification under now 63? Or must it say that disputed or not, there is an issue as to the very admissibility of this document? And I'm surprised we could not think of this. We've had judgment after judgment. If you read Arjun Pandit Rao, the last few paragraphs of that judgment, the Supreme Court has been at pains to say that we need reform in 65B. And they have pointed to the law in Canada in particular to say there is an option to cross-examine. If in cross you can impeach in some way the credibility, or let us say not credibility, but the accuracy or the believability of the electronic evidence, there is scope for the Sessions Court. But there aren't such threshold requirements to lead evidence. And here we say on the one breath that it is primary evidence, and on the other we subject it to the rigors of certification, etc. I'm quite sure the same predicament that was faced over the years with 65B will now be faced with this entire gamut of electronic evidence. Now, one other point I want to make is the very application of this BSA. Sir, you said goodbye to Evidence Act, but I think we have to say goodbye but see you soon. Because the Evidence Act and the IPC and CRPC are not going anywhere. And the repeal and savings clauses will be, I'm quite certain, subject to much interpretation. When does the new set of laws apply? It's no easy answer. If I look at this BSA itself, 170, the Indian Evidence Act is hereby repealed. Notwithstanding such repeal, if immediately before the date on which this Adhiniyam comes into force, there is any application, trial, inquiry, investigation, proceeding, or appeal pending, then such application, trial, investigation, proceeding, or appeal shall be dealt with under the provisions of the Indian Evidence Act as in force. Now, many questions come to mind. I'm quite certain, sir, this is going to require constitutional benches again to interpret it. And these provisions you will see also in the new procedural law. And obviously in the penal law, you cannot retrospectively have penal provisions. The constitution forbids it. But even on procedural law, the general rule was it is retrospective unless otherwise stated. Now both these procedural laws, the Evidence Act and the BNSS, say they are prospective. But how do you interpret this? Now what is the meaning of trial, inquiry, investigation, proceeding or appeal? When does trial commence itself? The BNSS is silent on. You have to now then go back to Supreme Court judgments, which said trial is deemed to commence when charges are framed. But that itself is a matter of judicial interpretation. So we don't know really when trial is deemed to commence. Is it when charge sheet is filed or when charge is framed? Let us take it that when it is charged. But this also speaks of investigation. So supposing investigation is commenced, the old act will apply, both CRPC and evidence. And the law is, under 170 of this, is shall be such application or investigation shall be dealt with or proceeded with. Does it mean the investigation can be under the old acts but the trial under the new? And how will that impact rights of parties? I cannot say. Again I say, it can impact either ways, but it does not sit well with the rule of law. But the general sense is this architecture is pro-prosecution. Having said that, it can work both ways. And interestingly, this 170 speaks of proceeding, but it does not speak of suit. Now you will have to interpret proceeding to include a suit, because this Evidence Act applies also to civil proceedings. What was the difficulty in mentioning it? I think it's a faux pas because you were never really thinking of the impact of this on civil law. I'm running out of time. I want to make one concluding statement, which is to say that I think now with criminal law in India, we have come to the conclusion, at least I personally have, I'm sure Mr. Gupta will share that view, that the focus in criminal litigation has become far more emphasized and focused on bail jurisprudence than actual trials, right? And as a result of which, I think there was a need for us in this Evidence Act and in this entire exercise to formulate special provisions to deal with this whole concept of prima facie. Today, criminal proceedings are decided prima facie. When I say decided, I don't mean finally. But for all practical purposes, this process is the punishment. बहुत सुना है, but अब देख रहे हैं. We are seeing that. You look at the judgment yesterday in Shoma Sen's case, 6 years in custody, Supreme Court says prima facie we do not file material. You look at the judgment in GN Sai Baba's case, an indictment of the trial court, it's not a case of benefit of doubt. The High Court said in the second round over that the trial judge really proceeded on a basis of no evidence. Where does this Evidence Act or the new codes deal with situations where trial judges are proceeding to deny bail and ultimately convict in very serious offenses without evidence? Should there be no consequence there? And therefore, I think there is, friends, a need for a prima facie Evidence Act. I don't know what the Sanskrit, I do not know what the Hindi or Sanskrit equivalent of it is, but I think it's very important because the larger criminal law works out not just under IPC or BNS, it works out under special statutes. And we are seeing now under PMLA, UAPA, NDPS, etc., the entire jurisprudence is different in terms of burden of proof, in terms of the manner of leading evidence, effect of confessions, etc. This was again, I think, friends, a golden opportunity. If we had to redo and reinvent the wheel, we should have actually then looked at the impact of these procedural and evidentiary provisions under special laws, look at them under the General Act, and then codify so that you could have a fairer legislation. I think that ultimately would lead to the, the spirit of the rule of law. Thank you very much.
Thank you, Dr. Aditya Sondhi. Those who are lawyers in this audience will be glad to hear from him that the new act will lead to multiple litigation heading all the way to the Constitution bench of the Supreme Court. And again, on a lighter note, I think the lacuna that he found in the legislation about civil trials was sought to be met by introducing the prima facie case into criminal trials. May I now invite Ms. Jayana Kothari, advocate practicing in the Karnataka and in High Court and in the Supreme Court, a very well-known advocate of many issues, particularly in the area of public law, the founder of Center of Law and Policy Research in Bangalore, an advocate, a teacher, an author holding multiple awards, which would only delay lunch for me to enlist in exhaustive way. Thank you, Jayana. We'd love to hear you now.
Thank you, Mr. Gupta, members on the panel, senior advocates, other advocate friends, members of BAI. Thank you to the BAI for inviting me for this conference and for this session. Today, as we speak on the Bharatiya Sakshya Adhiniyam, I have made a small PPT really to enable myself to understand it better in a way, and hopefully see what it's about. And as we this was enacted recently in 23 and comes into force from July 1st, 2024. And as many of the other speakers have discussed even in the previous session, it's it's quite similar to the Indian Evidence Act, which it seeks to replace with very, very minimal changes. And how do we look at those new aspects that have come into force? So I thought I'll just give a brief overview. The Act is, most of the provisions are very similar. There's a lot of renumbering and restructuring of the sections. Like the other criminal laws, there's been an effort made to remove certain colonial references, wherever the sections refer to the British Parliament, other colonial terms, those are, there's a point made to remove those references. And then I think the only aspects where it has made certain changes or added a few things are on the provision of electronic records and digital records. I'll go into that a little bit. It expands on what is secondary evidence, and then it adds a few more other minor provisions. So the biggest addition to the Act has been on electronic records. So it first says that any document includes electronic or digital records, and then it gives an illustration that these are emails, server logs, documents, all of that from websites, and all other kind of, an expansion is made. To some extent, this was anyway covered with the amendments made in the Evidence Act as it stands today, because electronic records have also been included, but this kind of makes it a little more explicit. And then it looks at it says that electronic records will be seen as primary evidence. So it says very specifically that electronic and digital records will be seen as primary evidence. It clarifies it that if documents are created and stored in multiple files, then each of those files are primary documents themselves. It also states that if they are equal to paper records, so an electronic record will be seen in the same way as a paper record as a primary document. I mean, though these clarifications are made, a lot of these provisions were already included in the Evidence Act with the recent amendments to include electronic records. I think one or two places where it makes a little more, clarificatory changes is that where it says that it is not just those produced by a computer, but also any communication device, because now we see that a lot more documents are produced by phones and other means. So that has been added. Importantly, the entire issue of the Section 65B certificate is retained, though it does not, it gives it in the schedule. There are two forms given. So those same provisions are there. The only difference I would say is that currently in trials, when electronic records are sought to be produced, though the Evidence Act at the moment talks about a certificate under 65B, often affidavits are also filed. Here there is a template given in the schedule, and not only does it say that the party can give it, an expert can also give it. And if an expert gives this certificate, then they also have, there are some additional requirements that you have to give the hash value, etc. Now this, are we going to move to a situation where instead of parties giving the 65B equivalent certificate, are you going to have more experts coming on record to give these certificates? Does the Act envisage that? I mean, that's something for us to discuss. The second issue is that there's been some expansion on what is secondary evidence. So secondary evidence has been expanded slightly to say that secondary evidence would include oral admissions, written admissions, and evidence of experts, so expert evidence. So if there's now this has been included as secondary evidence, and importantly, it expands and puts a provision that if for any document, the document is not seen as a genuine document, or there is some difficulty in accepting the original document, then you can provide a secondary evidence for it. But what kind of secondary evidence if there's a dispute to a document? There's no mention of that. So how would such a document by secondary evidence be proved? So, I mean, so while it expands it, there are some areas which leaves it a bit unexplained. And then there are certain other minor inclusions, I would say. For confessions, there's another, in addition to confessions obtained under threat, there is coercion included. For judicial notice provisions, these are again very, very minor. There was many academics have even made tabular columns comparing the Indian Evidence Act and the new code. And so for judicial notice, what things the court can take judicial notice of, even international treaties and international agreements have been included. In attorney-client privilege, for example, they've included the scope to include even employees or staff and clerks of attorneys or advocates. Now, this is, while this may be a good thing, I think in our trial and practice, the entire issue of attorney-client privilege itself we don't use too much, and that is not brought up in trials in a very strict way. But anyway, that has been expanded, and yes, so exclusion of production of any privileged communication between ministers and the President of India, that has been included if we do a strict comparison. So while we look at these changes, I think there are still some issues which remain. These are issues with the original, with the Evidence Act. But when there have been steps taken to expand its scope to some extent, for example, in expanding the scope of digital and electronic records, this was an opportunity where it could have been a way to address tampering of records. And that has not been done. Many issues were raised, both Aditya raised it, on the genuineness of the document, on the admissibility of the document. Even in the previous session, what do we do with tampering of documents and fake documents? And today we see that with electronic records, it's extremely easy to concoct electronic records. Today, in many trials, especially, we routinely, emails, of course, are produced, but we routinely see call logs, WhatsApp message logs. How do you ensure that these printouts and logs are in fact genuine? You give a 65B certificate or an affidavit, or even the certificate which is now required. You may even give a pen drive, but who is going to authenticate and verify that what is given is actually untampered by a party or by anybody producing it? What is the source of it? Is the phone going to be sent for forensic examination to first examine whether it's tampered or not? Photographs are produced, images are produced. Even without going to trial, we see online, the level of tampering that is there on social media. There are deep fakes which are at a very, very high level. So then what are we talking about? Ordinary electronic records produced in court, in trial, civil or criminal. Voice messages, videos, or call logs. How do we ensure that these electronic records, we are expanding the scope for electronic records we produce as primary documents, but how do we ensure that these are in fact genuine documents and untampered with? So that has not been addressed, and this leaves open a large area of concern. And then the certificates, and also by the other issue is by experts. It specifically refers to expert evidence. Are we, I think, in our civil and criminal trials, are our courts and lawyers, is the legal system going to be equipped to deal with a lot more expert evidence? This is not something, I think, that routinely our courts and lawyers take up. And so when we expand the scope, are we going to be able, is the system going to be able to take this up and address it and manage it, is something what we have to see. So yes, so overall I think the Indian Evidence Act remains more or less the way it is, with a little bit of minor restructuring and renumbering really. But I think core issues remain. This was an opportunity for an amendment of many other provisions. But unfortunately, those amendments have not been done, and I think we're left with many of these challenges that we have been facing, especially on electronic records. And so we have to, I think, really discuss how we take this forward and how our courts are going to manage these risks. Thank you.
Thank you, Jana. Perhaps the fact that the new act is more or less the same as the old one points to the fact that the old act was a very adequate act, even though it came in the 19th century. And on this question of expert evidence, Indian courts are very deficient. First of all, we don't believe in leading expert evidence. Why do we need to lead? Then the advocate's ability to handle expert evidence is not something which is worked upon, even though advocacy training programs around the world treat it as a separate subject of discussion altogether. And of course, therefore, the kind of assistance which the judiciary needs to deal with expert evidence is not available. And if the promulgation of this act has any effect on improving the quality of expert evidence in our jurisdictions, it would be welcome. May I now invite Mr. Yakesh Anand, who needs no introduction in this room. He's a vice president of the Bar Association of India, a very well-known figure in the corridors of high courts and the Supreme Court in India. We'd love to hear from you, Mr. Anand.
Thank you, Jaydeep. Dear Prashant, President Bar Association of India, Sachin Diok, President-elect, members of the governing body, and Executive Committee of Bar Association of India, my panelists on the dais, ladies and gentlemen. If something changes for better, it improves. Discussions changing the criminal laws in India has been going on for years. Now it has become a reality. It may not be the best, but it is better than what we had. Starting 1st July 24, the new laws will come in effect. The new laws, what was the need for changes? It's a question everybody has been debating. Why this government was in a hurry? Or what was the need for proceeding to have new acts? Let me see the rationale behind it. The new act is believed to have been enacted to get over the old archaic law framed centuries ago, where the section made reference to the colonial era. To ensure fair trial, given the modern day legal practices, especially with reference to technical advancement in India and abroad. It also enacted to ensure that the modern day legal system does away with colonial terminologies, colonial procedures, societal changes which the country is undergoing. Our criminal justice system, burdened by protracted delays, overwhelmed appellate courts, prolonged detention of under trial prisoners, was in dire need of reform. Further, the failure to embrace 21st century technological advancements hindered effective investigation and justice delivery, perpetuating systematic inefficient inequality. The new act emerged as these pressing challenges. New act versus the old act. One, this act applies even beyond jurisdiction of India. In section 1, the word India has been deleted. So even an offence is committed outside India can be tried in India. It can be cognizance can be taken. The definition of document has been changed. By expanding the scope of term document to encompass electronic and digital records as delineated in section 2(1)(d) and by incorporating information communicated electronically and into the definition of evidence is a very important step according to me in the new act. Various other changes have been made with respect to the oral evidence. Under the old act, oral evidence includes statements made before courts by witnesses in relation to fact under inquiry. The BSV Act allows oral evidence to be given electronically. This would permit witnesses, accused persons and victims to testify through electronic means. This is a significant move, as one of the primary reasons for delay in trials was where trials was requirement of witnesses to be physically present to make a statement. So any unforeseen circumstances would lead to adjournment. This provision would lead to speedy trial. Another important factor which needs to be considered is this amendment under the new act states that a witness who is unable to speak may give evidence in any other manner in which he can make it intelligible, as by writing or by signs, such as by making written application to the court and then give evidence. Further statements regarding confessional statements under section 22 of the new act has made certain changes with reference to need for confessional statements. Admission. The term coercion has been added in addition to inducement, threat or promise, where such confessions are inadmissible. Also, the new act retains most of the provision of the old act, relevancy of facts and burden of proof. The new concept, which is what we used to have section 24, now it has been expanded to mean joint trial, which is very important. The section 24 of the new act has added an explanation to the concept of joint trial, where it has been stated that if any accused has absconded or has not responded to an arrest warrant, it will be treated as a joint trial. The Indian Evidence Act used to state that in a joint trial, if a confession made by one accused, which also affects other accused, is proven, it will be treated as a confession against both. The new act adds an explanation to this. It states that a trial of multiple persons where an accused has absconded or has not responded to an arrest warrant will be treated as a joint trial. Friends, a lot of things have been said with regard to the primary evidence and the secondary evidence. Under the Act, old Act, the electronic records were categorized as secondary evidence. Under the new Act, the electronic records are being classified as primary evidence. It expands such records to include information stored in semiconductor, memory, or any other communication devices like smartphones and laptops. Now, this section also is in synchronization with the IT Act. Electronic records have to be in par with the documentary evidence. In accordance with Section 61, electronic records are now on a par. The Honorable Supreme Court in the case of State of Delhi versus, in other words, Sandhu, where it held that courts could admit electronic records such as printouts and compact discs as prima facie evidence without notification. This expansion broadens the range of devices and mediums from which electronic evidence can be sourced. This broader scope reflects understanding of evolving nature of technology and aims to accommodate various forms of electronic evidence beyond traditional computing devices. Section 63.4 is another good milestone, specifies format of certificates accompanying electronic evidence, replacing the previous requirement of filing affidavits. Certification of electronic evidence shifting from involvement of person holding a responsible official position to a person in charge of relevant device or activity and an expert. This update reflects a recognition of expertise required to authenticate electronic evidence, effectively ensure certification and issued by qualified individuals. Expert verification is another clause which has been added. This also discloses a certificate to be verified by an expert, stating that a particular hash value is obtained by applying a particular hash algorithm. Thus, the emphasis on expert certification increases the authenticity of the document submitted. Thus, the scope of types of or digital evidence could be expanded. Primary evidence. With reference to primary evidence as given electronically, like a voice note, shall be accepted as per the new Act. Accomplice is another definition which is elaborated. An accomplice shall be a competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice, says Section 138 of the old Act, and of the new Act, which means that conviction is not illegal if it proceeds on corroborated testimony or the evidence. Friends, we need to again look into it. What is other provision under the old Act and the new Act which are similar, like admissible evidence, confession made before a police officer is inadmissible. There have been some progressive steps taken under Section 114 of the old Act. There used to be a presumption. What one says, there used to be presumption that for accused to take in a matter or judge to see what is there or what is not there and the charges are framed or not, or there is sufficient evidence, or like my colleagues talked about what is the prima facie evidence. This section has been replaced with now the new section called 119 and 120. Under the new 119, the Act relates to court may presume existence of certain facts. It provides that the court may presume the existence of some fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, public and private business, and relation to the facts of a particular case. It further provides that a court shall also have regard to such given facts in considering whether such maxims do or do not apply to a particular case. Friends, now look into what are the certain criticisms to the new Act. The new Act has been attracting a lot of attention owing to linguistic accessibility of the same. Only 58% of India speaks Hindi, which is a little over half the country. Thus, many professionals are finding it legally inaccessible. This is one of the complaints they feel. The requirement for certifying electronic evidence as document presents a potential contradiction. While the omission of providing provisions mandating secure handling of electronic records raises legitimate apprehension about data protection and integrity, addressing these concerns will be crucial to ensuring the efficiency and integrity of our legal system in the digital age. In the quest to increase the scope of electronic records, the stakeholders stand compromised, like the intermediaries, like hosts of digital platforms, person working forward, analyzing and authenticity of the digital documents. A provision related to hit and run cases, which was a point of controversy under Section 106 of the Act, has been put on hold. owing to the opposition by truckers who had opposed against the stringent punishment of 10 years. The new act has been criticized to have been drafted within a short time frame, thus not being able to deliver through work. Even the draft bill was not put up for consultation of legal luminaries at least. The Law Commission's recommendation to have been ignored. For example, Ministry of Home Affairs in its 248th report had raised the following concern. The committee is of the opinion that safeguarding the authenticity and integrity of electronic records require doing course of investigation are prone to tampering. I am sure this point would be looked into in future. A complete deletion of Evidence Act 1872 was not needed. Amendments could have been sufficient. In a sense, the implementation of Bharatiya Sakshya Adhiniyam 2023 marks a significant stride in aligning the Indian criminal justice system with technological progress, thereby enhancing efficiency in this justice delivery system. As the new legislation takes effect, it is anticipated that the operationalization of its provisions and emergence of associated practical challenges will prompt the development of its own legal jurisprudence over time, offering solutions to these intricacies. Thank you, friends.
Thank you, Yakesh. The last speaker is Dr. Gandhi Kaza, and he brings a completely new dimension to this panel. He is a PhD from Osmania University and has studied at the City University of New York. He has trained with the FBI, the Interpol, the Metropolitan Police of the Scotland Yard, has had a career in the police and has risen to the rank of IGP, Inspector General of Police, and a Director of Forensic Science Lab. After his retirement in 2007, he has set up India's first independent forensic laboratory by the name of Truth Labs, of which he is the chairman now. He is a pioneer in the area of forensic science, and it will be very interesting to hear from you, Dr. Kaza. Please.
Good afternoon, everyone. My name is not known to 99% of the audience here. My organization is not known to 99% of the organization, of the people here. Naturally, I am a foreigner in this hall. I am known to only the President of Bar Association of India, and maybe one or two people sitting, coming from Hyderabad, Tanir Srinivas. Maybe a couple of the people must have heard. Otherwise, Truth Labs is not known, forensic science is not known, forensic knowledge is not known, not only to all of you, but also, fortunately or unfortunately, to judges, 99% judges, 99% of the police officers, 99.9% of the prosecutors, and my own colleagues, at least about 15-20% of them. But still, the country is going on. But we found the need to change the laws. Because one of the requirements, what they are saying is, technology has changed. I have only one question to ask. Is anyone of the persons in the hall have hesitated or stopped using this technology because the technology has changed, when the new technology has come? Everybody has one. There are two also in many of your packets, I have seen that. And when everybody has a laptop, and a desktop, and a server also. Nobody has changed. But to me, the 55th year of service, continuous service to the public only, I should have been the private servant, but I have been serendipitously brought into the forensic science. When I just passed my MSc Physics, appearing for competitive examinations, one of the chief intelligence officer of the state of Andhra Pradesh, look Gandhi, I am not Gujarati Gandhi. Because someone asked, are you from Gujarat? Are you from National Forensic University? I said, I am not Gujarati Gandhi. But I was born when Mahatma Gandhi died. And my parents thought, since Mahatma Gandhi visited my home on April 12th, 1927, just because my great-grandfather built a huge choultry on the main road between Vijayawada and Machilipatnam. Because he found the bullock cart people, the cyclists, the pedestrians who are walking from this side to that side, 60 kilometers at a stretch, they have to stop somewhere. And my great-grandfather had built a tank, huge tank for the washermen and other people, 4 acres land tank. And also built 6 wells, one by the side of the main road. And these people thought this is the biggest well we had in this road. Let us stop by. And he has also left along the side of the wall 1.5 acres of land. They were just staying overnight and then going. But he saw one day, in the rains they are just drenching, but they are just having shelter under the trees, but they don't have nothing. He felt they should have shelter. Huge shelter with 12.5 feet thick walls he has built. When Mahatma Gandhi was walking, during those days he was walking, people said that Velagapudi Pasarama Das Garu has built a choultry there, big choultry, why not you stop over? He stopped over and had a 2-minute talk with my grandfather. Very well built. You must be having some background. Yes, sir. I have built a temple and all that. Why don't you give, if you have little more money, to the trust? On 3rd day after he left, he created Sri Sita Ramanjana Charitable Trust and gave away 1/3 of the property to the trust and remaining 1/3 to 2 children. And some of you may be feeling that why Gandhi could start Truth Labs by himself. The trust property I am managing, I could sell some of the properties which he has given, and 5 crores I have donated to make Truth Labs possible in this country. Why that I have done? As I said, serendipitously I have been brought into this. I would have been the Electronic Corporation of India Limited chairman by this time, or when I left this country, having joined police as intelligence officer and having started the first IB director, B.L. Malik, has started under Intelligence Bureau Forensic Laboratories, because this is a modern technology has been used for evidence, conversion of evidence into a viable proof for building the curiosity system. He thought only central governments can start, under Intelligence Bureau he started. There was a suggestion from my well-wisher. First time it has come, you should start now, you should become a forensic scientist. He called me for interview. So what is forensic? I didn't know the spelling of forensic. I had to take little Lifco dictionary, FORENSIC. That was the starting point. Since I have, my parents and grandparents were dinning in my ears, we wanted to name you as a Purnachandra Rao. Since we were born when Gandhi died, since we loved Gandhi, Purnachandra Rao I will remove, Purnachandra Gandhi is my name. This is the secret behind Gandhi. From then on, what they started dinning into my ears, you born when Mahatma Gandhi died, you have to do something good. Should not tell truth. My mother, like Mahatma Gandhi's wife, She stopped taking food when it's really a lie. That was how I have been brought up. Talk, think, talk, and act truth only. That's why Truth Lab's name. All this happened because I have befriended during this time. I'm sorry to say, if I'm little, only the people who are honest and hardworking, who believe in truth, and who believe in integrity, who believe in nation, believe in patriotism. That's why 3 former Chief Justices of India are my close friends, even today. I walk daily in the morning walk, in Hyderabad, in the park, National Park, with former Director of National Judicial Academy, Dr. Raghuram, Mr. Raghuram, all of you must be knowing, Bhopal, and Mr. Kamal Kumar, former Director of National Police Academy, plus a host of other people who are senior people, and Prashant was my guest. When I completed 15 years of my Truth Labs as an independent forensic laboratory, where Justice Venkatachalaya has given his inaugural address, 2 former Law Commission of India chairmen have come and attended personally. 3 former Supreme Court judges have come and attended personally. And my Truth Labs was inaugurated, first Truth Labs inaugurated by Justice Singhvi. There's an important point I have to make here. Justice Singhvi said, I do not know Gandhi, who is done exceedingly well in this country, set up a model lab for the entire country, a leading lab for the entire country, having been brought back by Andhra Pradesh state government to head the police academy here, and later on he was asked to take over the forensics laboratory, and he made it well, making entire country's police and judiciary also to come here to get the cases done with his expertise. Truly, the CBI used to register some of the cases. Somebody was saying Naval War Room Lake case or Cochin ship. All these cases were brought by the SPs and IGs of CBI directly to Hyderabad after having registered it. Sit in my room and get the jobs done in 7 days. Some of you are saying that 6 months, 6 years, 60 years also there are some cases. Truth Labs will not keep any case more than 6 days. If it's a simple case, 20 days or 25 days is a bad case. It's a complicated case where the evidence itself is not up to the mark. Then we seek clarification, we take it. Now, I don't want to say more about me, but what is that is happening? All of you must have heard, men may lie, material objects will not lie. You heard it? Is it familiar to all of you or no? You have not heard, I think, most of you. Circumstances are material objects. Circumstances means material objects will not lie. But I must tell my experiences. In reality, what is the conviction rate in India? Let us not go to the petty cases. Rape cases, what is the conviction rate? Roughly. Little accurate, please. What is the conviction rate in India for rape cases? Someone just now told Ram Manohar Lohia Hospital, Ram Manohar Lohia College. He said in the discussion, 28%. What is the conviction rate for murder in the country? It is also hovering around that. Have you improved the conviction rate over a period of time? Have anybody thought about it? No. There is an excellence execution problem in this country, not only in this area, but also in every area of the country. That's why our people excel when I go to Europe or UK or USA or some other Commonwealth country. Let us not blame Commonwealth countries or colonial law. I am also telling one more thing. I have nothing to talk about the laws, but still I am just giving a reference. Because the technology has changed. Has any of these countries have changed their laws? Evidence Act, Procedure Act, or other acts? They have not changed. And one more important thing. When I was brought back from USA, I would have been the Deputy Chief of Police of New York City Police as of today, because there is no retirement age for them. I was called back by N.T. Ramarao. You may have heard of N.T. Ramarao. When he became the Chief Minister, he said, our police should be properly trained because people are unhappy about the police. We sent them to the National Police Academy. They said National Police Academy is only for IPS officers, not for others. Why did you not have Police Academy for Andhra Pradesh? Telugu Rajyam, Telugu State. Then they said, we don't have. Then while going to our residence every day, he was having 300 acres of land lying idle next to the tank. He said, I'm allotting this 300 acres of land to Andhra Pradesh State Police Academy. The first State Police Academy was started by him in 1987. Then when the DGP, Home Secretary, Chief Secretary was asked, we want the people for that. The first director, Nyaya Reddy, one of the most professional police officers in the country, out of the top 100. He selected my name. He said, where is he? New York. From where he has gone? From state government. Why he has gone? Call him. I came back immediately. Mr. Gandhi, why did you go? Because the state government fails to take my services properly. I have to waste 90% of my time. Only 10% I am being utilized. Home Secretary, Finance Secretary, Chief Secretary was sitting. Why it was being done? He knows that state governments work not to the satisfaction of the people, but to satisfaction of the. Then he immediately said, Dr. Gandhi, where from you hail? So and so village. Next to my village only. What is your father's name? Grandfather's name? So and so. You must be knowing my father. Yes, sir, I know your family also. Why did you go without telling me when you are going, when I became CM? Sir, why should I come? I was not happy, I went away. Then come back. Immediately got my postal car allotted, vehicle allotted, government quarter allotted, and post rank also was upgraded based upon my service. I started 1970 in the intelligence department. Because I was selected by the state government as director to DSP, you should be given rank. I was made IG of the police for the first time in the country. Then next one. I made a difference. All of you should know, must be knowing about ISO 9001. ISO. Since I have just come back from USA, we should have a standard procedures and techniques for forensic laboratory to work. All our people like this. I went in. Sir, why are you bringing these standards here? If you give the standards, we have to do so many things. Work will get delayed, procedure will get delayed, and we will not be able to do anything. Means we will not be able to do anything easily. With no standards, no procedures, no acts. I said, this is my requirement. Then they started saying that if you have to do this, we need 6 months to 1 year. So let us see first what is that we need. We need more people, we need typists, we need computers. No. I went to the government and said that these are the things they need. And they are keeping 8 years cases pending. 8 years rape cases pending. I said, I can't tolerate this. I have still green card available. I want to go away. And the government said, no, what do they want? They want this. We'll give them in 30 days. How much do they want, time they want? I said, if you give 30 days, I'll ask them to give 90 days. They said, 90 days not possible, sir. Then what do you want? Then they said, they are not giving us a higher salary. They are not bringing us on par with the police ranks. We are not being treated properly. And the skills are being upgraded. We want rank equivalent to that. And they said, I will also try to do that because CM is in favor of us. No. you are known for your integrity, hard work. You will get the things done by making us do work. You will get rank and you will get higher salary. You will be forgotten. I said, I will not take my salary till your skills are upgraded. 18 months I have not taken my salary. I got them also upgraded. We built the country's first and only ISO 9000 government department in India. And Chandrababu Naidu, who came to give us applaud, said, how many people are there? 170. One advance increment, effective till the retirement and after retirement also. This was the first time and only time done in this country or anywhere in the world. After retirement also, people are taking advantage of this. And from then, no looking back. CBI, 20 states have come to us to get their important cases done. My dear friends, with this, I thought the people of the country has given me a lot of respect, regarded me as their own person. That's why they gave me all this. Police have come. I need to do something. Then I asked my wife, parents, and children also, I want to start this. I will not take loan. I will not take government loan. I will not borrow from anybody, because if I fail in this experiment with truth, I lose my whatever image I have in this country. They allowed me to sell the property. First started in Hyderabad. Justice Singhvi inaugurated, and Justice Singhvi said, why this gentleman has done this? When the truth is a casualty in this country, why truth labs, how truth labs can work? And he gave an example. My dear President, sir, you have to give me a little time, maybe little time I will take. These are the things you must listen to. He said, recently I had a meeting with all my High Court judges and district judges and senior officers. And I said, if there is a theft in your home, what is the first thing you will do? They are just sitting idle. They are not answering. Raise your hand. How many of you are going to the police station? He asked. Everybody was just, Arey, you have lost your property in your own home. What is that you are going to do? Then one of them or two of them said that if the property is more than 10,000 rupees, we may go to the police station. Why? 1,000 rupees is not money. No, sir, hassles of the system. Police will come, research, they lost my wife, my father, my grandfather, all of them are there. They will have. That means the system has not yet matured in this country to be able to provide relief to the victims of crime. And if we are victims of crime, we are not able to do that. Who else will be able to do that? We have to change this. That's what I said. That's why I said, truth is a casualty in this country. Anyway, I'm wishing him well. The governor also was there. Chief Secretary was there, Chief Justice was there. All of them pretty well knowing, how can this Gandhi start a forensic lab independently? When it's a domain of the government, nobody can start a police station. Nobody can start a court. Why could start? Other people said, the credibility which has established will make them, whether he gets the cases or close the office. Second day, newspaper has come out, government inaugurates. Two police officers, one district judge has sent cases to us. That's the starting point. Today, Truth Labs is expanded to Delhi, inaugurated by then Chief Justice A.P. Shah. Chennai, inaugurated by no less than APJ Abdul Kalam ji. And then M.O. Iqbal. Then Karnataka, Bangalore, Santosh Hegde and Justice Malimat. Like this, now we have got 6 offices across the country, Kashmir to Kanyakumari. Victims of crime, no tooth labs. In a select few officers, judges, legal officers and judges, like Prashant Kumar, are associated with important cases. And some of the activists, like Arvind Kejriwal, he was getting cases, important cases done by him much before I was still in service. People know about it, and this is what is happening today. Now, I asked a question about the men may lie, material objects will not lie, or circumstances will not lie. How many of you, if I say, believe circumstances and material objects are being made to lie? All of you know the truth, but how many of you are going to say that yes, do you agree or not? You won't say, but you have agreed in your mind. But is it what we are? Because all of us are sitting here on the 3 acts. Ultimately, when there is somebody violates the laws, rule of law is the hallmark of democratic systems, democratic country. Equality, fairness, liberty, and justice. Then only these laws will come into applicable. When the violation, what is the next step for violation? What is the remedy? Proof. Evidence. Evidence is the essence of proof, foundation of proof, medium of proof, fulcrum of proof. And for 90% of the cases, material evidence has answers. Only thing is one should think of material evidence. And now you are calling digital evidence. Some of you are saying it needed to change because digital evidence is not included. My dear friends, soon after I came back from USA and given the position of police academy, I started having the first, one more thing, very important thing I'm telling you. In the entire world, forensic science as a part of the police academy is not there anywhere in the country, in the world, except in 10 countries. That includes Scotland Act, Interpol, and German police, and New York City police, and New York Police Department, where there are 3 people for physical, chemical, biological sciences. I added medical sciences because the evidence is, if the crime is against persons, automatically medical officer will come into picture. It's a different thing whether the medical system in the country is working or not. None of us care about it. The poorly being administered, poor execution of all the medical evidence. I have changed that also in my state. But fortunately or unfortunately for this country, if somebody changes to the biggest level, the next person will change it back for good or for bad. If somebody takes to the heights, we are not able to retain it. That's why, because I made ISO 9001 and ISO 17025, after me also, the AP Forensic Laboratory could not spoil it less than 70% level. It's running well. Thank you. And then, now coming to the point, so the understanding of forensic science or technology or material evidence is a must if you have to really improve the conviction rate from 30 to 80 or 90, like what is happening in USA, not the change in the laws. And here, I don't want to take more time. I have to tell you one more thing. Having been rubbing shoulders every day, morning and evening and days, with the top judiciary, retired of course, serving also, of course they are still senior advocates. Even Raghuram also is working as a senior advocate now. Arbitrations and mediations which you have got in Hyderabad. All mediation heads, including Chief Justice of India who retired, lockups of India people who retired also come to me for taking material evidence. And they are immensely getting benefited. Those who do not, who want to use 2 telephones, cell phones, cloud forensics, cloud phones, Even deepfakes also have been doing it. If we don't understand the technology, we'll continue to be there at 30% hovering, 70% of the victims suffering in this country. I want the judiciary. We have been doing it. National judiciary, I address every day. But rarely they will understand the depth of it. This is necessary, and that's why no other country will fail to appreciate, use, apply, and this for making it more possible. Unless this is done, this is not going to happen. With this, I got 4 minutes.
No,
Okay. Okay. I thought I'll take. I don't want to take more, but thank you. And then I don't want to be in lunch and queue. Thank you very much. I thank once again Prashant for having been using my forensic evidence in all important cases. I have to tell you last point. In a presidential case, in a prime minister case, my reference was taken, but I said I will not give written opinion. Even in the cases of heads of other countries, I have given opinions. But there I could go and stand before the court of law and say, this is my evidence. Here, I said, I do not want to do that. You know the reason. Thank you.
Thank you very much, Dr. Kaza. Lawyers are always preoccupied with how to use evidence, and the substance of the Evidence Act is how to use it in a court of law. We do not spend perhaps enough time on how evidence is to be developed. But yes, until and unless we know how evidence is to be developed, we will not be able to advise anybody in getting a conviction. Thank you very much. We are at 1:15. If anybody has a question, we may stay here for another 5 minutes. No. We will end with Pravartak, no doubt. But if anybody has any question. Yes.
I have a quick question to the panelists that with the amendment and all that which has come into place, what's happening with the new technology which is there, which is like deep face, artificial intelligence? You have now videos, I have seen some, I've done a little bit of research where you can create an entire video just by coding. You don't need physical presence of people who are gone past. So I believe they are now trying to take rights of dead actors from their family so that they can recreate a Rajkumar having a movie today. So with that kind of technology, money being put into technology, how will the current act, Evidence Act, deal with the nuance of finding what is correct and not, and especially in the context what Mr. Sondhi said, that it's prima facie, means with that quality of video evidence being produced in a so-called, let's say, an alleged rape case or a murder case, by the time it will be proved in 6 months or 6 years, the person, the accused, has already undergone. So just a quick feedback on that.
Would you like to? Anybody wants to?
Answer by saying, I mean, one is, of course, by the time you find out whether it's fake or genuine. But I'm saying that, will you even figure out whether it's fake or genuine? I mean, forget about the time, because with so much development in technology, do we have whether we have forensic labs who can figure it out? Do our courts have the means, do the procedures have the means that at every stage before production of evidence we check whether it's genuine or not, or tampered, or how authentic it is? So none of those provisions are really there, and that, I think, makes it worse.
Let me stand to make it more clear. Any change that has taken place, in your mind you will think something. You know that thought is not correct. Are you sure about it? Your mind has changed your thought from good to bad. Likewise, if anything that is changed, whether your mind, it is your neurological, or in a material part,
there will be a change. Somebody said hash value. Who said hash value? You said hash value. Hash value changes for anything that is changed. That's for the technologists to understand it well, and the legal fraternity to seek that technology. Everything that is changed will be detected. Like your mind, which changes your thought, will be detected. Nothing. Only thing we have to use technology. Thank you.
Now I would request if yes, of course.
The question of deep fakes and everything, the technology, whether you call it forensics or otherwise, you can always see the source of generation. When you put it through digital mapping, you know whether it is an artificial construct or it is a genuine, reproduction through photography, through other things, even in a digital form. So what is happening, we are getting overawed with so many things coming, and the artificial intelligence, the whole kind of, it's being taken as a gospel, spread around without understanding. It is not so complex. What happens, till you put it through examination, all this confusion remains there. Because what is being shown as a virtual reality, it looks real. But the moment you put it under scanner, you know what's real and the fake. So the question is the temperament and the capacity to utilize these things and how to build it in the procedure, or like in the provisions of the Evidence Act. Now, one of the cases which we did, the journalists charged in OS, under OS. And the devices, both phone and laptop, had evidence connected to that particular thing and also lot of other information which is protected in terms of journalistic privilege, and even some other information which, if spread around, could have caused havoc. And no protocols at all that you just take, even the question of making a mirror image. How to make a mirror image only of that particular segment? How to isolate it? What are the norms and other procedural safeguards laid down to separate the information relating to a particular crime or a possible crime and the other information which is present there? Are your systems, because some of these things are being given to random private institutions, and that is what was being done in this case. So how to do all this? So when you are bringing amendments or you are deciding in courts, the effort has to be to lay down these parameters. So in Bombay High Court we made an attempt, but unfortunately or fortunately the case itself got quashed. So, but what we succeeded was to get an order. One of the most excellent judges on the criminal law side, Justice Mohita Dere. So we were able to get the order that till these norms are laid down, give the devices in sealed cover to the protonotary. So the devices were with the registrar till this exercise is done. And we took the assistance of Truth Labs to explain the nitty-gritties, that how this can be possibly technologically done or not, what could possible parameters be there. Now, unfortunately, since we as lawyers are not equipped, we don't understand how this process works, and we think it is complicated, we also don't raise these issues while dealing before the court. But ultimately, it's very very easy to say digital evidence, this evidence, that evidence, but unless until you have done all this groundwork, these procedural criteria are laid down with finesse and refined further with the help of technologies and others, all this is going to create more confusion, more trouble, delaying disposal of cases. So that is where we need to work. And one of the things which I am proposing in the Bar Association of India is to start regular training courses for the lawyers in our new building, in collaboration with Suraksha and the University in Sanhita, where these nuances are at least understood, so that when we can't influence the government, we can't influence the legislative work, how they do it. But what we can do, we can render assistance to the courts. To do it, probably we ourselves know how things can be done and how to ourselves take assistance. So that is an initiative which we'll be doing. That's why I invited him to be here, so that we can at least kickstart this thought process.
Thank you very much, Prashant. It's certainly a worthwhile initiative that we must follow up. May I invite Mr. Pravartak Pathak to bring this session to a close.
So we are here on the end of this session. I must thank to the Honorable Chairman and all the dignitaries and distinguished speakers. The session is closed. Now we can proceed further. Thank you.